Tonight, we tackle a timely and thorny topic of individual freedoms in the age of social media. The Founding Fathers protected important rights from individual freedoms, right to privacy, the right to a fair trial, but now online social networks are creating an entirely new set of questions and challenges. Colleges and employers reject applicants because of publicly available information and photos found on social networking sites. Jurors post details on a case and ask their friends to vote on whether the defendant should go to jail. Marketing companies are facing lawsuits for allegedly collecting information about citizens based on our travels on the web without our knowledge or consent. How would the Founding Fathers have handled these scenarios? What would happen if social networking sites were subject to the Bill of Rights? We have a fantastic group of experts with us tonight to delve into this subject, starting with Lori Andrews. Professor Andrews directs the Institute for Science, Law, and Technology at Illinois Institute of Technology. As a law professor, her work assesses the social impact of emerging technologies. She's also a best-selling author. Her latest book is entitled, I Know Who You Are, and I Saw What You Did, Social Networks and the Death of Privacy. And we're honored that Professor Andrews has chosen the National Constitution Center as a venue to launch this book tour. Please join Professor Andrews for a book signing after tonight's program in our lobby. Kashmir Hill is a staff writer at Forbes, where she explores the intersection of law, technology, social media, and personal information on the blog The Not So Private Parts. Before joining Forbes, Hill was editor of the legal blog Above the Law. She also has worked for such publications as The Week and The Washington Examiner. Jennifer Preston is a staff writer at the New York Times, where she covers the relationship of social media with politics, government, business, and real life. Ms. Preston took on this new beat in January of 2011 after working as the newsroom's first social media editor. A veteran reporter and editor, Preston began her career right here in Philadelphia at the Bulletin newspaper and the Philadelphia Daily News. She also serves as an adjunct professor at Columbia University's Graduate School of Journalism. Moderating tonight's discussion is Christopher Wink, co-founder of technology news site Technically Philly and its parent company, Technically Media, a media services consultancy for the online ecosystem. He leads Technically Philly's Transparent City Open Government Reporting Project in addition to coverage of city IT policy. His writings have appeared in the Philadelphia Business Journal, the Metro, Philadelphia Inquirer, Pittsburgh Post-Gazette, and the Morning Call. And now I ask you to silence your cell phones in consideration of your fellow guests, but I encourage you to use them. If you'd like to tweet questions for our panel tonight, please use the hashtag #NCCPrivacy. And now, without further ado, please join me in welcoming Lori Andrews, Kashmir Hill, Jennifer Preston, and Christopher Wink.
Thank you, everybody. Apologies for starting a little late. It turns out lapel mics are tough to put on people who don't have lapels, so it took a little bit, but we're here. As Stefan put it, 225 years ago, the Constitution was written here in Philadelphia. And in subsequent years, the foundation of our democracy, the communication patterns and issues of privacy were developed. And 225 years later, new communication forms are developing new standards for that. So as Stefan said, we have a great panel, and I want to jump right into it with Lori, actually, by telling us why the social web is a constitutional issue. Maybe ground us first.
Fathers would have loved Facebook, Twitter, and Google. They were techies. They even have a clause in the Constitution, the patent clause, to encourage innovation. But they also were very concerned about things like privacy, the Fourth Amendment, preventing the cops from going in and finding a letter in our drawer in our house. But now everything private about us is in the cloud. It's not in the drawer in our house. And so I think we have to figure out ways to protect things we care about, free speech, right to a fair trial, and so forth, in the digital world.
So what are we talking about? Maybe give some of the names of the organizations, of the services that we're talking about, and then let's bring in our other panelists. So who are we talking about? For people in the audience, who are we talking about?
We're talking about not only Facebook, think about it, private data on 800 million people. It would be the third largest nation in the world after China and India. It has its own currency, it has its own economy, and it has dealings with other nations, China, so forth. And yet, there's no real regulation about what is done with information about you posted on the website of Facebook. And if you think about it, 800 million people's private information, if a government tried to get that, it would take laws, it would take lawyers, it would take guns, and yet we're freely giving that information up. So we're talking about that. But we're also talking about companies you've never heard of. Axiom, a data aggregator that has 1,500 bits of information on 96% of Americans. We're talking about Nebuad, a company that made a deal with internet service providers in California to put their hardware at the internet service provider and copy and analyze every email, every web search, Skype calls, everything that anybody sent, every Google search over the web. Now, they're in litigation, there was just a settlement, but we've got to think about the many ways in which our private information has now become public, monetized, potentially used against us.
So I want to turn to Kashmir. Obviously, Lori's talking about comparisons to nation states. It seems like the beginning of this conversation about how we're comfortable with what the web entails is a reasonable expectation of privacy. And I think there are those who would suggest, well, it's ludicrous to think that. You are choosing. This is not a sovereign nation. These are choices. Talk to me a little bit about, kind of that feeling of reasonable expectation of privacy, if any of us deserve it to have it on the web, and kind of where that comes from.
I mean, there are many different ways in which we are on the web, and I think we have different degrees of privacy depending on which area we're talking about. So I think it's fair to say that we have a reasonable expectation of privacy in our email, which is something private. But when we're talking about increasingly public forums like Twitter or Facebook, I think that there's less of an expectation of privacy when you're broadcasting in a place that people can look at and read. So I think we really have to differentiate in terms of which forums that we're talking about. And I think because of the way that Facebook has changed over the years from being more of a private place to being more of a public place, people are still adjusting to that. And just this whole idea of putting a lot of information about ourselves online and out there, a lot of people get uncomfortable and it's used against them just because they're not thinking of how exposed they really are.
I'd like to comment on the fact that emails are considered private, and I think there should be a reasonable expectation of privacy in emails, but that's not what the courts are finding. A New York judge said your email should be treated like a postcard, as if you were writing to anyone. And if you look at court cases, for example, one woman who was really injured in a personal injury case, the judge actually used her Facebook picture of her smiling to say, oh, she can't be that hurt if she's got a smiling picture on Facebook, not even asking if it was from before the accident. And so, and people might know enough not to have drunken photos of themselves on Facebook, but often things are used against you when you wouldn't think about it. A glass of wine, holding a glass of wine at a wedding. 35% of employers say that they've turned down job applicants because they've held a glass of wine in their hands. And you have things like people who are, young, poor kids who are charged as gang members because they're wearing gang colors. And that I love. I mean, I looked at the Los Angeles Police Department definition of gang colors. It's plaid, think any hipster, all black, New York art opening. And so I don't think we understand that seemingly innocuous pictures to us could be problematic. The woman who loses her child in a custody case because she's got a sexy picture up on Facebook. It's not knowingly giving up your privacy. Yes, I'd say Twitter, YouTube, you're talking to the larger population, but sometimes it sneaks up on you in terms of how this is used.
I want to get more of a dialogue going, but quickly, I want to put this in context about the importance, right? Like, so often in the United States, when we're looking at Facebook and Twitter, we'll see it as trivial. But Jennifer, maybe talk to us a little bit about why social media, and when we're looking at how the Constitution is involved and how the Founding Fathers might see it, how much more important social media can be seen. We're looking directly at the Arab Spring, something that you were involved in reporting. Talk a little bit about why the social space and these questions are a lot bigger than just what we may see here in the States.
Well, the privacy issues that we're discussing tonight are very important. But what's also important is these platforms turned out to be enormously powerful tools in countries that where